Welcome, my name is Stephen Wood. I'm the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia. Welcome to the No-Fly Zone speaker series, which brings legal thinkers and actors from around the world to speak virtually about pressing environmental law issues. It's a way of fostering national and global knowledge exchange without generating travel-related greenhouse gas emissions. Today, we're joined by American lawyer Kelsey Skaggs, Executive Director of the Climate Defense Project, who is going to speak to us about the project and how it provides legal support for the climate movement. I, the center, and the law school are uninvited guests on the traditional, ancestral, and unceded territory of the Musqueam Nation here in Vancouver. Indigenous peoples across Canada and around the world are frontline environmental defenders, putting their bodies and lives on the line to defend the land and to honor their relationships with Mother Earth and their non-human relations. They are harassed, beaten, arrested, charged, and prosecuted by police and the courts with the support of private security. And they bear the brunt of the coercive power of the state in the service of climate heating industries. Today's talk will be recorded. It will be available on the Center for Law and the Environment website. If you have any questions, please type them in the Q&A window, the button that's available at the bottom of your screen at any time, even during Kelsey's remarks. You can see questions as they're posed, and you can upvote questions that you would like Kelsey to answer. After Kelsey is done speaking, I will moderate the Q&A. And let me just introduce our speaker. Kelsey Skaggs is the co-founder and executive director of Climate Defense Project, a nonprofit that provides legal support and strategy to the climate movement. Climate Defense Project fills a gap in the legal landscape by representing climate activists, developing legal strategies, and connecting attorneys with communities and campaigns. Kelsey has worked on environmental justice issues at Cragg Law Center in Oregon, on international environmental policy at the Universal Rights Group in Geneva, and in defense of free speech activists at Media Legal Defense Initiative in London. When she was a second-year law student, she filed the lawsuit Harvard Climate Justice Coalition Against Harvard, the first lawsuit seeking to compel institutional fossil fuel divestment. She and her co-founders launched Climate Defense Project upon graduating from Harvard Law School. Kelsey has received recognition, including the Echoing Green Climate Fellowship, the Straubel Leadership Award, the Civil Society Fellowship, the Harvard Law School Public Service Venture Fund Seed Grant, and a place on the Forbes 30 Under 30 list. It's such an honor and a pleasure to have you join us virtually, Kelsey. Welcome, and over to you.
Hi, everybody. Thank you so much for having me. I'm really excited for our conversation. I'm currently in Alaska, so I'm joining you from Tlingit Ani, from unceded Tlingit land. We honor the people who have been stewards of this land for over 10,000 years, and my colleagues and I support efforts at decolonization here and everywhere. I have some slides to share with you all. Stephen, does that look good? Great. So I actually grew up here in Alaska, where I'm currently based, and my family's cabin is in an area that's legally designated as wilderness. It's on an island with no towns, no roads, and no people other than us. When the first owner built the cabin, it was just the frontier, so he was allowed to sell it once. My family bought it, but it can't be passed down. When the current owner dies, we have to deconstruct the cabin, burn it to the ground, and let the place return to wilderness. For me, it was a place of complete freedom. after I finished hauling wood for the stove, I could sail my little boat around, spend hours looking at tide pools, and cook fish in our smokehouse. And in fact, for a lot of people in Alaska, life kind of revolves around fish. I help my family fish for our food, like many Alaskans who rely on subsistence hunting and fishing. We caught salmon, halibut, lingcod, rockfish, and crab, and my family also hunted mostly for deer. My brother gets seasick, so I was always the one who would get up before dawn and drive the boat when we trolled for salmon. Hand trolling, what we did, is a very physical way to get your food. You let down a line with a cannonball at the end to lay it down, and you have hooks that stream out behind the boat as you drive slowly back and forth. Every time a fish bites, you have to crank up that cannonball through hundreds of feet of water by hand, and then you catch each fish individually. So you quite literally know where your food comes from. This is a map of Alaska. My hometown, Juneau, is on the lower right-hand side in that orange territory with the arrow. Juneau is pretty remote, and by that I mean it's not on the road system. So you have to get there by plane or by boat. Growing up, I would walk out my front door into the largest national forest in the United States. And the thing about living in Alaska is that it teaches you about your place in the world. When you go out for a walk, you have to stop and think about what gear you're going to need, because your life can depend on bringing the right layers of clothing. This teaches you that you're part of the natural world, not apart from it. So after a community presentation I gave recently, an elder asked me, do they know? Do people know that Alaska is in a crisis right now? Alaska is on the front lines of climate change. It's warming twice as fast as the rest of the United States. And I'm sure that you all know that climate change is bad. We all know that. But this is what that looks like for me. Most visitors to my hometown, Juneau, go to see the glacier. When I was growing up, I would go swimming there in the summer and ski and ice skate on the frozen lake in the winter. But this place that I love is changing. Because of climate change, the glacier is receding, and I can see an enormous difference just in my own lifetime. You can literally watch it happening. This time lapse is over only 7 years. So much of Alaska, especially further north, is covered by permafrost in normal time, which keeps the land stable and kind of holds it together. But now the permafrost is no longer permanent. Higher temperatures are causing massive stretches of Alaska to erode at dozens of feet per year, displacing families who have lived there for generations. Fishing, again, is Alaska's lifeblood. And this fact amazed me when I learned it, which wasn't that long ago. Every community in Alaska has salmon nearby. For most villages and towns, salmon are extremely important in terms of subsistence and cultural meaning, and often in the cash economy as well. And of course, the rest of the ecosystem also depends on fish, including the bears. This is my friend Lexi. She learned to walk on her grandparents' boat, and when she was 15, started working on her family's fishing boat. She and her husband Adam started their own business called Fish and Family Seafood, and now they bring their 2 kids along on fishing trips. But because of climate change, the fish runs are precarious. People are seeing that herring, the tiny fish that form the basis of the ocean's food chain, are not returning. And there have been summers where the weather is so dry that there isn't enough water for salmon to swim upstream to get to where they need to spawn. If the fish aren't able to come back and spawn and create new fish, it will not only devastate people like Lexi's family, Alaska's entire economy and entire culture will be completely changed. So Alaska is warming, and it's warming fast. But of course, it isn't just Alaska. We are the canary in the coal mine, along with parts of northern Canada, because climate change is happening everywhere. And at this point, everyone has something they love that is threatened by climate change. We could spend a long time on the details of climate change science, but that's not what we're doing today. So here are the key facts. The world is getting hotter and it's happening fast. Humans are causing this. There is no meaningful scientific debate on these points. This warming has devastating impacts, and it is still possible to avert the worst consequences. What we need to do is actually simple. 1, stop extracting fossil fuels, and 2, transition to renewable energy, which is becoming cheaper and cheaper. If we cut our emissions dramatically, we can still prevent some of the worst effects. Now, when I say that this is simple or possible, I mean that it is technologically feasible. We could do it. Whether we will do it is another question. When I first went to law school, I figured that I would find a way to work on the legal side of these questions. And then I actually studied environmental law. American environmental law was developed in the 1960s and 1970s. And before that, there was no such thing as environmental law in the United States. But in response to efforts by activists, courts and lawmakers started paying attention, and eventually a few key federal laws were passed. The Clean Air Act, the Clean Water Act, the National Environmental Policy Act, and the Endangered Species Act. That is still the dominant framework. So American environmental law is administrative law. This means that it establishes and relies upon administrative agencies like the Environmental Protection Agency. And the way that these agencies function is not strictly to protect the environment. In fact, it is literally to permit environmental destruction. They issue permits for industry activities that are harmful to the environment. This management scheme is also very siloed. So one piece of legislation provides the protection of species, one deals with air quality, another covers water quality, so that the environmental protection that we have has been very piecemeal. This patchwork legal infrastructure is really not set up to facilitate the kind of holistic response that we would need to address a crisis like climate change. And furthermore, and perhaps most importantly, these administrative agencies are very vulnerable to influence by the industries that they are supposed to be regulating. In the decades since this legislation was passed, industry representatives have become very, very good at pressuring the agencies and at getting what they want, which is generally less regulation. This is particularly true when we're talking about fossil fuel companies, oil, coal, and gas companies, and about climate change. They're the experts at this. I think it's clear that something has gone wrong, right? Our collective response to the problem of climate change just doesn't make sense. Why have we continued to extract fossil fuels? Why are we not implementing all of the renewable energy technologies that we can? Why is the response so utterly inadequate? Well, according to a US senator, the fossil fuel industry has structural control of Congress. Judge Goodwin on the Ninth Circuit put it this way: the current state of affairs reveals a wholesale failure of the legal system to protect humanity from the collapse of finite natural resources by the uncontrolled pursuit of short-term profits. The heart of the issue is this: climate change is about science, it's about data, but it's also about money and it's about morality. The companies that extract fossil fuels from the earth and sell them are some of the most powerful entities in the world. They spend huge sums of money on lobbying governments so that not only are they permitted to continue their destructive business practices, but they receive billions of dollars in subsidies to do so. And in our capitalist system, that's exactly what they are supposed to do. Their goal is to maximize value for their shareholders to make as much money as possible. But of course, along the way, they have knowingly caused the harm of climate change. The people who run big fossil fuel companies like Shell and ExxonMobil, they knew about climate change starting in at least the 1970s. And their own scientists told them that if they kept producing fossil fuels, it would have terrible impacts on the world. Sometimes I get asked, can we really pin the blame for climate change on this handful of companies? Don't we all use fossil fuels? Aren't we all responsible? But here's the thing, that is what the fossil fuel industry wants you to think. The industry has actively promoted this frame of mass guilt, the idea that everyone is responsible for climate change because we all drive cars or we all need energy. Here's an example from a blog by Suncor, a Canadian oil company, telling us that everyone is the problem. But that's just not true. The accurate blame frame is this. Exxon knew about climate change half a century ago. They deceived the public, misled their shareholders, and robbed humanity of a generation's worth of time to reverse climate change. Shell knew. The oil giant's 1991 film warned of climate change danger. The people who run fossil fuel companies have continued extracting fossil fuels for decades, even though they know that it would have devastating effects. They lied to the public about it on a massive scale. They bought control of the governments that were supposed to be regulating them. And they did it all to make money. So because of their lobbying efforts, consumers do not have freedom of choice. We don't have meaningful options when it comes to where we get our energy. And that is their fault, not ours. The thing about the mass guilt narrative is that it's very disempowering. It makes people feel like there's nothing we can do about climate change, and it makes them reluctant to confront the problem head on because they feel guilty about it. So step one in addressing the climate crisis is to recognize who is really responsible. The good news is that people are realizing this, and they are taking action based on this understanding. I'm going to use the umbrella term, the climate movement, to talk about this. My first experience with this movement was as a law student. I met people who were organizing in their communities and finding ways to fight climate change where they lived. They were working to prevent new fossil fuel energy projects, trying to shut down old ones, and trying to lead the transition to renewable energy. I met other students who were trying to get our university to stop putting its endowment money into the fossil fuel companies that are causing climate change. And through organizing with them, I learned how movement work happens and about what activists need. One thing that activists need is lawyers. Two experiences taught me this. The first was when I sued Harvard, and I was a second-year law student at the time. I am going to show you a clip from this documentary called Necessity, Oil, Water, and Climate Resistance, which tells this story.
That's literally so funny.
I was a first-year law student at Harvard right around the time that the fossil fuel divestment movement was taking off.
Hi, this is Ben Frana from Divest Harvard. I'm calling because there's a student protest for fossil fuel divestment happening right now.
There's a very active group of which I became part, trying to get the university to take their endowments out of funding fossil fuel companies. And they just did not want to even talk about it.
I need that door wide open as well as the stairs. If the fire department comes here, nobody can stay here.
Ultimately, we started a campaign of civil disobedience, doing blockades.
We were looking for an open and transparent dialogue with Harvard Corporation about divestment, and so we can only speak with someone who has the power to negotiate on behalf of corporations.
Our only request was for an open meeting to talk about these investments, and rather than have that meeting, they had a student arrested. Harvard's slogan has Veritas, truth in it, and I felt like the administration was hiding from the truth of what their investments are doing to the world and the futures of their students. Allison, Ted, and I all met through the fossil fuel divestment activism at Harvard. And when nothing else was working, we got together and started to talk about litigation.
University officials wouldn't meet with members of the campaign unless it was behind closed doors. It became clear to the campaign that the best way to get them to go on the record, in a public kind of way and engage with our arguments was to, file a lawsuit against them.
Good morning. I'm Justice Seifert. To my right is Justice Granger. Our first case is Harvard Climate Justice Coalition and Others versus Harvard Corporation and Others, 2015 P0905.
No judge wants their courtroom to just be used as, a stage for theater, but there's also a long and distinguished tradition in the law of using courtrooms and legal advocacy in sort of more of a First Amendment tradition, a way of allowing juries who are representatives of a community to really engage in a real way with some of the most pressing issues that are facing a community.
Under our second count, our tort count, we are representing the interests of future generations. Future generations, of course, are not able to come into court and represent their own interests. And in the special circumstances of climate change, where these injuries are far from speculative, they're severe and certain, we think that there must be some judicial flexibility to allow their interests to be heard before the court.
So we filed this lawsuit, the first lawsuit for fossil fuel divestment, back in 2014. Fast forward to 2021, and folks at universities all over the US are asking for help with legal strategies to get their schools to divest. We help campaigners argue that their universities' investments in fossil fuel companies violate the laws governing nonprofit investors. Investing in fossil fuel is inconsistent with their fiduciary duties. So far, we've partnered with divestment campaigners at 4 universities to file legal complaints with their state attorney general offices. 2 of them, Cornell and finally Harvard, have subsequently divested. And in fact, in announcing divestment last month, Harvard's president echoed our argument. He said, given the need to decarbonize the economy and our responsibility as fiduciaries to make long-term investment decisions that support our teaching and research mission, we do not believe such investments are prudent. This language is pulled straight from the complaint that we filed against Harvard. And there's a lot of momentum behind this tactic. We have more complaints lined up, including some that will be announced this month. And it's really exciting to see the momentum behind it. I'm not going to get into the specifics of our legal argument today, but if you are interested in this, please feel free to get in touch. And I'm also happy to discuss this more later in the Q&A. But back to law school, my friends and I also started working with people, with activists off campus. Organizers in the community were like, we need legal support. You're basically lawyers. Can you help us? And we said, not really, because we haven't even graduated yet. But we realized that there was a need for legal support and strategy rooted in the climate movement. And then we looked around trying to find ways to fill this need. And we found that no one was really working on climate law specifically in a movement-based way, which isn't actually surprising since it's not really a field with developed law yet. The existing environmental legal framework, as I discussed, is so poorly suited to the goals of the climate movement. Activists needed something new. And that's why we founded Climate Defense Project. So we work alongside activists in the climate movement, and a lot of the legal work that we do is new and hasn't been done before. But climate activism itself is not brand new. Decades ago, people realized that climate change was a problem. And they said, well, in the US, we live in a democracy. So they asked their elected representatives to deal with this threat and to rein in carbon emissions. But the necessary regulation never came. Companies kept drilling for more oil, Renewable projects were blocked by lobbyists. The problem is that the fossil fuel companies are just too powerful, so that there's no way for the needs of regular people, even an entire planet full of regular people, to really compete with the influence that these companies have over our elected officials. And we work with political scientists who have actually measured this effect. They show that although there is broad support among citizens for stronger climate policy, this is outweighed by corporate interests. And this means that no amount of voting, of talking with your elected officials, or testifying at public hearings, none of that is going to work, because we will never be able to out-lobby the fossil fuel industry. The system is broken. Now, when it becomes clear that a political system is broken, people eventually start to ask, if all of the regular tactics for creating change are ineffective, then what do we do? One answer is civil disobedience. So what does this mean? In this context, it's when people intentionally and non-violently break the law in order to address the injustice that is climate change. When the system is broken, civil disobedience can be democracy promoting, and it can be transformative. We've seen this throughout history. My examples are drawn from the US, because that's my jurisdiction. This is true elsewhere as well. For example, civil disobedience was instrumental to the abolition of slavery in the US. Congress passed the Fugitive Slave Act in 1850. This made it illegal to allow a person to escape slavery or to help a person escape slavery. Of course, abolitionists fiercely opposed these laws. Henry David Thoreau wrote his famous essay on civil disobedience, specifically arguing that people should disobey immoral laws. And the entire Underground Railroad was a deliberate, repeated violation of the law. This open resistance increased tension in both the North and the South, and conflict intensified until most citizens of northern states opposed slavery. It changed public opinion. And this set the stage for the end of legal slavery. The women's suffrage movement used creative civil disobedience to pressure the president, Congress, and state governments to recognize women's right to vote. Susan B. Anthony was arrested for voting illegally. Protesters picketed the White House for months, the first time, by the way, that that tactic was used, and many of them were arrested. They were treated terribly, which shocked the country and increased support for their cause. And their continued protests compelled state and federal officials to ultimately pass laws allowing women to vote. The US civil rights movement of the 1960s also famously used civil disobedience. Rosa Parks became well known because she broke the law by refusing to give up her seat to a white person, sparking the Montgomery bus boycott. And other tactics like lunch counter sit-ins at, quote, white-only restaurants were widespread. These acts of civil disobedience increased pressure for racial equality, leading directly to the passage of the Civil Rights Act and the Voting Rights Act. And in fact, if you go back even farther, the United States was arguably founded on civil disobedience. The Boston Tea Party, which rallied American colonists to fight for independence, was an illegal act of protest against an unjust system. So civil disobedience can be an effective way of changing social policy, and it can work when everything else has failed. And so climate activists have started to use it. One of the ways that civil disobedience works is that it dramatizes an issue that can seem abstract. So for example, until the 1950s, much of the US was held enthralled by the illusion of incremental racial progress, that it was gradually improving. That illusion was broken by acts of civil disobedience like the lunch counter sit-ins. These protests clarified the issues in the civil rights struggle. They established a narrative with moral and legal dimensions, and they galvanized political progress towards racial equality. Now, of course, we still have a very long way to go to realize that goal, and acts of protest continue to play a role in making that clear. Civil disobedience can also bring home the severity of the climate crisis. When people are willing to put their bodies and their freedom on the line, it can prompt others to consider the issue more deeply. And sometimes when people talk about climate change, we talk about the scientific data and the impacts that are happening and that will happen, but it can be hard to feel a connection with the impacts of climate change. Although I have to say this is changing every day as more and more extreme weather events and disasters occur because of climate change and more impacts become apparent. But there is still a disconnect, and I hear this from folks all the time. And so civil disobedience dramatizes the urgency of climate change. It also can create problems for authorities and force governments to take an issue seriously. The interesting thing is that even a few people engaging in civil disobedience can make a massive difference. 1%. That is all it took to win significant civil rights legislation. 1 in 5. A Yale study found that 1 out of every 5 Americans say that they are willing to personally engage in civil disobedience to stop climate change. That is a lot of people. If that actually happened, if those people acted, it would completely change the political reality. So what does climate civil disobedience look like? What are we really talking about? Here are a few examples. Standing Rock is probably the most famous example of climate civil disobedience on this continent, at least, the protest camp in so-called North Dakota. Thousands of people engaged in civil disobedience to stop construction of the Dakota Access Pipeline. The photo on the left here is of a person in Pakistan digging a mass grave in anticipation of the deaths that would be caused, and in fact were caused, by unprecedented high temperatures due to climate change. And the photo on the right is of activists in Massachusetts. They are lying in a trench where a new fracked gas pipeline is being laid. They are protesting the graves that this new pipeline will cause. The photo shows some of the hundreds of people who participated in civil disobedience over the course of months to stop this pipeline. Some of them, including Al Gore's daughter, Karenna Gore, who's pictured here, became our clients. These clients stopped the flow of oil through 2 Enbridge tar sands pipelines that run from Canada through Minnesota in 2019. They did this by turning the emergency shutoff valves on the lines and explaining that we're in a climate emergency, so emergency shutdown is appropriate. And by the way, this valve turning tactic actually originated in Canada. So these are some of our clients, and they have interesting goals from a legal perspective. Sometimes they care more about communicating their case than they do about minimizing their legal risk. This is sometimes a strange mindset for the criminal defense attorneys that I work with, because our instinct is usually to minimize legal risk for our clients. But sometimes they actually want to use legal arguments that expose them or can expose them to greater risk. In the tradition of political trials, they want to use the legal process to further the goals of their campaign. So in a sense, the action doesn't end with their arrest. It continues through their use of the legal process. And we've seen that climate activists are starting to proactively use the legal system and to think about their trials before they even engage in a protest action. Political trials can be really helpful to a movement in several ways. And this applies to climate movement and also more broadly. First, they can be a powerful platform. They can spread a message. So a trial like this can be a way to educate people about climate change and the need to respond to it and ways to do that. Second, a political trial can be a good structure for presenting facts on issues like climate change. The great thing about these trials is that the scientific data becomes part of the evidence at trial because we present it. So it becomes part of the record. And especially with so much climate denial, it's really important to find ways to publicly present actual climate science. These trials are also an exercise in democracy because you have the jurors brought in as representatives of the people, and they have the opportunity to weigh in on one of the most important issues facing their community. They have the opportunity to say, yes, we do need action on climate change. Political trials can also help move the law itself in the right direction. None of our systems are set up to deal with climate change, and that includes our legal system. But courts are going to have to respond to climate change one way or another, and we're pushing them to do this in a just way. And then finally, the legal system can produce results that the other branches of government simply can't. That's how it's structured. So for example, a federal judge recently determined that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. These kinds of sweeping judgments really only come from the court. So one way that we pursue these advantages of political trials is through something called the necessity defense. This allows somebody who broke a law to say, yes, I did break that law, but it was justified, and here's why. So to understand this, imagine that you are walking down the street, you see a house on fire, and you hear a child crying inside. Because you are a good person, you break down the door and rescue the child. You could be charged with a crime because technically that's trespassing and possibly also some sort of property damage depending on what you did to the door, but no jury is going to convict you. The necessity defense is a very old piece of law. It comes to the US from the common law tradition inherited from the United Kingdom. So it is the law in Canada and other Commonwealth countries, as well as in the United States. One of the early cases was about a ship captain who was prosecuted for throwing cargo overboard during a storm. And he proved that he had to do it to avoid sinking and was found not guilty. It's also been used by activists in a variety of social movements. So for example, in the 1980s, a group successfully used the defense after being arrested for protesting CIA activities in Central America. It's also been used successfully by people protesting things like nuclear weapons, apartheid in South Africa, and air pollution. In climate change cases, we use the necessity defense to argue that civil disobedience is morally and legally justified because the other means of affecting change have failed to bring about strong climate policy, and because this failure has catastrophic consequences. The necessity defense is a legal argument, but it's also a moral argument. It allows the jury to acknowledge that sometimes laws support an unjust system, and people are justified in peacefully breaking those laws. Okay, this is the legal nitty-gritty, just to show you how it works. The elements vary slightly by jurisdiction between states and countries, but in general, the defendant has to show that she, 1, was faced with a choice of evils and chose the lesser evil. 2, acted to prevent imminent harm. 3, reasonably anticipated a direct causal relationship between her acts and the harm to be averted, so some showing of causality and effectiveness. And 4, had no legal alternative but to violate the law. So here's what a climate necessity trial looks like. Imagine that you are all on a jury and I'm the lawyer for a person who was on trial for trespassing, for stopping construction of a new pipeline. My client grew up in the area and lives near the place where the new pipeline is being built. Now she's a grandmother and her family lives there too. The new pipeline is being constructed close to their town, their water source, and important animal habitat. My client is worried that it will leak or explode because she knows that all pipelines eventually have problems. And she knows that even if there are no problems, it will contribute to climate change that will be catastrophic for the planet and for her family. So she did everything she could think of to stop this pipeline, but none of it worked. And then she studied civil disobedience and how people have used it in the past. With a group of other grandparents, she chained herself to a tractor that was being used to build a pipeline, and they shut down construction. She was arrested, as she expected she might be, and now we are at the trial. The judge tells you, the jury, that if my client was acting to prevent a greater danger, and if she didn't have any other options that would work to stop that danger, then you can find her not guilty, even though she did lock herself to that tractor. And by the way, my client admits this freely. She explained that her protest was necessary because nothing else worked. She had already tried testifying at hearings, marching at demonstrations, writing letters, talking to officials, and none of it worked because the fossil fuel company that is building the pipeline has more money and more influence than any group of regular citizens. That company is in control of what the regulators do. So she explains that there was nothing else she could have done to protect her family. She says they need clean water. She talks about how she grew up fishing and boating and she wants her grandchildren to have that too. And I also bring in some expert witnesses. So I bring in Jim Hansen to explain climate change to the jury. He walks you through how bad climate change is, how species are already becoming extinct, and the harms to human civilization. And in fact, he says, these harms are not just imminent as required by the law. They're not just imminent because they're already happening. I bring in a professor of political science, and she discusses the long and effective tradition of civil disobedience in this country. She explains how people have changed policy by committing acts that are technically illegal. And she gives examples like those I discussed, the abolition of slavery, voting rights for women, and the civil rights movement. And then I argue that what this activist did in going onto the site and blocking construction is the lesser evil. It is nowhere near as serious as the catastrophic harm that will result if this pipeline gets built. And then I ask you, as a juror, to find that what she did was justified. One reason that we need a really powerful, really moral framework like the necessity of defense to talk about climate change is this. The problems that allow our governments to ignore climate change are the same problems that contribute to other social injustices, like racism, like patriarchy, like xenophobia. Climate change is a social justice issue. It's not just about environmental conservation, whatever that means. It's about people, and it shares roots with these other problems. So that means to me that the solutions have to be connected as well. In the climate movement, we use the concept of a just transition to get at this. And, you know, it might be possible to find a purely technical solution to climate change, one in which we just replace big oil with big green energy and these underlying equity problems aren't solved. There are certainly people working on climate change from this angle. But first of all, this would be a massive missed opportunity. And second, I actually think that in order to get to a place politically where technical solutions can be implemented, that's going to take a movement of people confronting power, a movement that includes tackling related injustices. So while climate change is terrifying, and it definitely is, it can also be an opportunity. Because in a way, climate change makes it clear that the way that we've chosen to organize our society in relation to Earth and to one another is deeply, deeply flawed. So addressing climate change can be our chance to rethink our social structures and tackle inequality and injustice in all their forms. And that goal is really at the heart of the work that we do at Climate Defense Project. I put my contact information here. So please feel free to reach out, especially if you're interested in the campus divestment work, which is so far just in the US, but definitely has the potential to expand. But now I would love to take your questions.
Before we take questions, I just want to say thank you so much, Kelsey. That was a really rich and powerful presentation, and just leads to so many interesting follow-up questions. We do have a Q&A function that I would welcome anybody to type a question into. And as we wait for that to happen, Kelsey, is it possible for you to turn on your video now? I should have actually explained at the start that thanks to a Zoom update just in the last 24 hours or so, Kelsey had found that she could not share her screen and have her video going at the same time. So that's why people were not able to see Kelsey while she was speaking. So I apologize for that technical glitch, but I'm going to pass the blame on to Zoom.
Is it working now? Can you see me?
You know what? You were muted just then, Kelsey. Let's see if we can get your... Oh, actually, no, that's fine. I think it's because of... You weren't muted. It was because I had my speakers muted. But yes, let me pose a question to you to get things rolling. I want to take you to the recent climate defense cases. There's been a recent victory of sorts for the necessity defense in the state of Washington. But I wanted to ask you, how would you respond, or how do you respond to people who say engaging in civil disobedience is always a personal choice and there's always another way, so that there is always a reasonable alternative to breaking the laws that are involved in civil disobedience or climate protest? That's what the courts in British Columbia here have said to climate protesters. And that's what a number of courts in the United States have said. And the Washington Supreme Court finally said, no, we disagree with that. But numerous appellate judges have said just that. So what do you say when you're faced with that argument?
Yeah, it's a great question. And so of the 4 prongs of the necessity defense that I put up on the screen, that fourth and final one, which is that the defendant has to show a lack of reasonable, lawful alternatives, is usually the trickiest. Usually, somewhat hearteningly, I suppose, there isn't a ton of debate about whether climate change is happening in these cases. Prosecutors and judges aren't obstructing that argument. Usually, we don't even get too hung up on the fact of whether it's imminent or not, because the science is so clear, although sometimes we get a little bit of pushback on that point as well. The third is, of course, showing that civil disobedience is effective. We have been able to make that argument pretty clearly with the experts and the research that we have, but it's an easy way out for a court to say, well, of course you had alternatives. There are always alternatives. We had a judge in North Dakota rule against letting us present the necessity defense based on the fact that, as they said, we could have run a public information campaign on television. Maybe the problem is people just don't know about climate change. And so, a lot of times I think that it hinges on the definition of that word reasonable, right? I mean, fortunately for us, the language is not, there are no alternatives. Because of course you can always do something different. That doesn't mean it's going to work. And there are 2 ways that we go about showing that there aren't reasonable alternatives. One is, as I mentioned, to bring in political scientists and folks who have actually measured the relative power of fossil fuel industry interests relative to those of ordinary citizens and the mass of people who want more climate action. Those numbers and those charts are pretty stark. And so working with people like Professor Gillens, who's at UCLA, who's one of our expert witnesses who have actually studied these things, is compelling, and courts are used to dealing in that kind of expertise. Another way that we approach it is, which I don't think is actually essential to meet this criteria or to win the case, but that can be really helpful from a narrative perspective, especially when you're talking to a jury, is to actually show the things that the defendant tried before. And to be clear, you could have a defendant who has never done any sort of climate activism ever. This protest is the first thing that they've ever done. And I believe that you could still meet that prong. But it can be compelling to also say, you know, for 30 years, this person has been trying all of these avenues within the system and they have been foreclosed. And I think that our argument in many ways becomes stronger as time goes on and the fossil fuel industry continues to set the tone in terms of regulation and policy. It also grows stronger for the fact that climate change is, you know, imminent and a disaster that must be avoided. Pretty much anything is a lesser evil at this point. So I think that that is one reason that courts are starting to agree with our arguments on that prong. And you mentioned the Taylor case in Washington State, which was one of the first and definitely the clearest kind of endorsements of that, because the court not only said, yes, this climate activist can present the climate necessity defense, but specifically agreed with us in addressing that lawful alternative prong and said that yes, alternatives to law breaking must be effective in order to be considered reasonable, but just because democratic avenues exist, that doesn't preclude activists from raising the necessity defense. And in this case, the activist, George Taylor, had back in 2016 peacefully blocked train tracks used by oil trains. And so the court did look at the facts in this case and say he had presented sufficient evidence to have the necessity defense be presented at his trial. So that case is going back to trial at this point, and it is definitely a big endorsement of our strategy and a big victory for us, and has major implications for future cases in that jurisdiction.
Do you know, by the way, when the new trial will be?
I don't believe it's been set yet, but I'll keep you posted.
Okay, so it looks like there's a question in the queue, and I will pose it to you. It is from Austin Earhart here, actually at the law school at UBC, who asks, are you aware of any examples, particularly climate-related examples, of the necessity defense being used against government directly? I'm curious how that may affect the reasonable alternatives argument, as the government is both the party at issue and the decision maker.
So feel free to jump in, Austin, if I misunderstood your question. The necessity defense is just that, it's the defense. So there are two different types of law, right? There's civil law, which is where, like under tort law or something, if somebody has done a wrong to you, you can sue them for redress. There's criminal law, and in criminal law, the parties are always the state authority. So for example, you know, Washington versus Taylor, in the case we were talking about, the state represented by the prosecutor against the defendant. And those are the two parties in a criminal action. And a defendant, it doesn't really work the other way around. The heart of this argument and the kind of moral part of it could potentially be used in other contexts. And there are lots of lawyers working on creative ways to kind of incorporate these values and the moral ideas that underpin this type of law into other legal actions. But in terms of the necessity defense, that's part of criminal law. And therefore it's brought up in the context of a individual or individual climate activists facing criminal charges and offering the defense as a response to those charges.
Yeah, thanks. And I would invite Austin to type in another question in the Q&A if he wants to clarify what he was getting at there, if it was something different than what you've just said. In the meantime, though, Kelsey, can I ask you to speak a little bit about the services and resources that the Climate Defense Project provides to the climate movement? And for anyone who hasn't already, I would invite people to browse the Climate Defense Project website, where it describes a lot of those things. It would really be helpful, though, to get a sense of the range of what you do.
Yeah, sure. I think a range is a good way to describe it, because our goal has always been to be as responsive as possible to the needs of the climate movement. And even developing the arguments that we're using now has, to some extent, happened in conjunction with our activist partners. And a lot of this really goes to the heart of how we think of ourselves as an organization. In many ways, we're climate activists who have law degrees. So our loyalty and our identity is kind of activism first, and we really believe that climate activists should be able to use legal strategies and legal tools as much as possible. The other side certainly does use the legal system very effectively, so we want people to feel like they can bring the fight there, and also that facing legal consequences in the context of civil disobedience, for example, can be an opportunity if they want it to be, rather than just something to defend against. So we provide a wide range of services. We talk with folks about know your rights trainings and that sort of thing. We provide background information on the potential for political trials, people thinking about that kind of option. For our necessity defense clients, we work with them all the way through the trial and appeals processes. And then our new program stream, which I mentioned briefly, working with people on university campuses to get their endowments out of fossil fuels, again, was really, brought about by people just contacting us. It started in kind of late 2019 into 2020 that I think people just maybe came across the information that we kept online about the 2014 divestment lawsuit, or were so frustrated with their university's intransigence that they said maybe we could get some legal help with this. So that's a good example of a program that we would always have loved to do, but it wasn't until students primarily came to us asking about it that we've really put the effort into creating that legal argument and creating the model of Attorney General complaints for divestment. So lots of different things, and we also just do a lot of kind of referrals, helping people find local attorneys. Our preferred model is to partner with local attorneys in the states where we're running cases, because we're a national organization. We're not barred in every single state. And we do best when we can partner with people who have on the ground knowledge.
Thanks so much for that. Kirk Juncker from the University of Cologne in Germany has a question for you. For his own environmental law clinic, expert witness fees are what stop much of their work. You managed to pull outstanding experts from all over the US. Is everyone volunteering? And I would also ask, what about the local attorneys that you work with? Because I can imagine the expenses mounting dramatically.
Yes, so we have been really lucky to work with expert witnesses who are all volunteer. When we have a trial or something for which they have to travel, we cover those costs. But for the most part, we are able to find people who, they're climate scientists, they believe in what they're doing, or they're experts of another sort who would like to see their work taken seriously and talked about in court, and who kind of believe in what we're doing, as well as being, impartial experts. So we've been very fortunate with that. Likewise with volunteer attorneys, most but not all of the volunteer attorneys that we work with are partners. Sometimes we have people who are paid, and in that case we work with the campaigns or the clients to do fundraising around specific trials. Climate Defense Project provides our services pro bono, and I'm very proud of that. We do not charge our clients.
Well, thank you so much for that. Believe it or not, we are out of time. I would like to thank you very much, Kelsey, for sharing your experiences, your knowledge, your ideas, and your inspiration with us and everyone who is attending online. And just to remind people that a recording of this session will be available for future reference on our website. And please check back to our website for future events, future talks in this No-Fly Zone series, and also other virtual and in-person events that the center organizes. So thank you so much once again, Kelsey. We really appreciate it, and keep up the excellent work.
Thanks.